South Carolina Governor Henry McMaster signing the fetal heartbeat bill into law today, but as our Brooke Butler reports, the law could still be blocked in federal court.
Planned Parenthood and the Center for Reproductive Rights filed a federal lawsuit today in an effort to strike down the fetal heartbeat law. They say they don't feel it's constitutional.
Bills just like Senate Bill 1 that ban abortion starting at about 6 weeks in pregnancy are clearly unconstitutional based on decades of Supreme Court precedent.
The fetal heartbeat law, signed by Governor Henry McMaster Thursday, requires anyone in the state who wants an abortion to get an ultrasound first. If a fetal heartbeat is detected, which typically happens between 6 to 8 weeks of pregnancy, the abortion cannot be performed.
We have a duty. It is a duty that we share as Americans and as South Carolinians to protect life above all else. That's what we're here for.
There are exceptions, though. An abortion can be carried out if the pregnancy poses a threat to the mother's life. If the woman seeking abortion is the victim of rape or incest, they can also get one, so long as the doctor gives their local law enforcement the patient's contact information.
Really involving law enforcement and taking the decision away from the rape or incest victim just is re-traumatizing them.
Despite the concerns, Governor Henry McMaster insists the law is a win for everyone.
The young, the old, the rich, the poor, weak, strong, known, unknown, or unborn, all have the right to life.
But others insist it sets a dangerous precedent.
It is absolutely unconstitutional. It is dangerous. It is going to hurt South Carolinians. It's going to make it more dangerous for anybody who's pregnant or parenting to be able to seek health care.
And it's important to note that Georgia's fetal heartbeat law was struck down by a federal judge just last year. Brooke Butler, WJCL 22 News.